Well, thank you, Janae, for having us present today. It's a real pleasure to do this. I hope this is a valued benefit to your members that are on the line. You know, as we've learned over the years, sharing data with other hotels can have serious legal consequences if not properly handled, and that's kind of what we want to talk about today. And I just quickly, our agenda, we'll go over my bio and Bruno's bio, who will be on this with me, and then a quick legal history of wage collusion, which has been a growing problem in terms of judicial issues. Some recent lawsuits that are out there that are impacting the situation. The Department of Justice has set up some survey guidelines and how to exchange information. We'll go over that, how to legally share your data, and some current price-fixing lawsuit in California that Bruno is pretty familiar with. And then we'll have a little questions and answer session after that. So let me start with about WageWatch. I think some of you on the line are probably users of WageWatch. Right now we have over 5,000 hotels that participate in our wage survey. We've been doing surveys, I have, since my days back at Deloitte & Touche when I was a partner there, going back to the early 90s. And we started the internet-based survey in 1999 here in Phoenix, and Texas was they were kind of like the initial users, and then we expanded it across the United States. We also, as part of this process, we became aware of the Department of Justice guidelines through our attorneys. We made sure that we set up the system to comply with their guidelines. We are essentially the preferred survey provider for compensation wages for most major hotel companies in the U.S., and as well as the California Hotel and Lodging Association. So I'll let the next slide is regarding trade associations, our affiliations, California Hotel and Lodging Association. You can see the American Hotel and Lodging Association. We do lots of things with the American AHLA that we might talk a little bit about later. International Society Hotel Association Executives, Resort Development Association, Staffing Association are all their preferred survey provider. And now I'll turn it over to Bruno so he can talk a little bit about Wilson Elzer Law Firm. Bruno?
Good morning, everyone. Bruno Katz here. Wilson Elzer is a full-service law firm that was founded in 1978. As you can see, we currently have 23 offices, including affiliates, including an office in London and affiliates in France, Germany, and Spain. And we have 3 offices here in California, San Diego, Los Angeles, and San Francisco. We have a large hospitality practice that spans nationwide, dealing with all kinds of issues from real estate, construction, intellectual property, employment law. And we're one of the original members of the Global Alliance of Travel, Tourism, and Hospitality Attorneys, as well as an active member in CHLA, as well as other lodging organizations, including the California Restaurant Association, American Hotel and Lodging Association, National Restaurant Association, etc. So I'll turn it over, I think, to Randy next. Well, actually, it's to me. I want to talk real quick about
it's still going to be you. You're going to talk a little bit about Sherman Antitrust.
Right. The Sherman Antitrust Act was passed in 1890, and the whole purpose of the act was to do 2 things, was to preserve the competitive balance in the United States. It was originally passed because there was concerns about large corporations that were basically restraining the ability of smaller competitors to do the same thing. It really wasn't enforced a lot until Teddy Roosevelt's administration against corporations. In fact, the original enforcements were against unions, Eugene V. Debs and the like. But it has 3 basic elements to find a violation. 1, there must be an agreement. 2, it unreasonably restrains competition. 3, it affects the interstate commerce, and a lot of you probably heard a lot about interstate commerce when we were dealing with the Affordable Care Act, and the Obama administration wanted that to be an interstate commerce provision, and ultimately, as everyone knows, the Supreme Court found it valid because it was under the tax authority, not under the commerce authority, but that's another thing. The other violation is there is a possession of monopoly power in a relevant market, and that the willful acquisition or maintenance of that power as distinguished from the growth or development is a consequence of a superior product, business acumen, or historic accident. And so those are what you're looking for in violations. And then the government has been active in enforcing this from time to time. They've had issues dealing where the Department of Justice has alleged price fixing or wage fixing in a particular market that stops the ability for the marketplace to have true wage freedom, and under the Sherman Antitrust Act and subsequent acts such as the Clayton Act, as well as the Business and Professions Code in California, there are certain violations that result in monetary amounts of not just the monetary penalties, but as well as treble damages, which means you triple it, as well as the awarding of attorney's fees. So that gives you a little background of what is the foundation for a lot of the price fixing claims they're alleging going forward. And there's a history of price fixing. The Boston Survey Group had technically coded documents to confidentiality, and there was two major hospital association groups. One was in Utah, where the Department of Justice in the 1990s filed suit against 8 Utah hospitals and the Utah Hospital Association and the Utah Society for Healthcare Human Resource Administration, in that they were basically charged with illegally conspiring to exchange wage information regarding registered nurses. In fact, resulting in a stabilization of the nurses' entry wages and limited the amount and the frequency of the registered nurse wage entry increases in Salt Lake County, Utah. This involved practically all the hospitals in that area, and this conspiracy supposedly spanned over 8 years, and it grew out of face-to-face meetings, surveys, telephone calls amongst the hospital, and eventually it did result in injunctive relief and restraint. On the other side, the Connecticut Hospital Association and 33 of its member hospitals, including acute care facilities, sued the the Connecticut program on how they had reimbursed Medicaid hospital charges, and that they basically were saying that the Connecticut program was a violation of the Medicare Act. And so basically they were arguing that the Sherman Antitrust Act preempted, and that it dealt with the whole field of the Medicare Act, and that they were being shortchanged in what was defined of their policy. What ultimately happened in this is they found that the Connecticut Act, in fact, was not preempted, and that there was not a violation of the Sherman Antitrust Act. So it can be used in both ways. And as Randy will discuss, because of these cases, it brought about some Department of Justice policies and guidelines. Randy.
Well, thank you, Bruno. And that kind of brings us to the next slide, which is what we deal with and all the surveys we do. And we do surveys for the hospitals and healthcare clinics, as well as gaming institutions, as well as the hotel industry. So we're very aware of what these requirements are, and we make sure that our surveys comply. And there's 3 major points that come into play here, and that's the survey typically needs to be managed by a third party so that you don't have direct access to the information. And we're aware of some situations around the country where one of your members basically conducts the survey for the benefit of everybody else. And it doesn't create a problem so much for the other members as it does for the member who is actually the one conducting the survey, because they obviously have access to the information, and they are at a facility or a hotel as well. And also as part of that, there needs to be at least 5 hotels reporting their data in the set. And that's a very key thing, and that's why we always limit in our surveys that there's at least 5 properties in the competitive set, one of which can be your own, of course. And the results can only be shown in the aggregate form, and this is also important. There are other more technical in nature which we follow, such as making sure the age of the data is at least 90 days old, so we test the data to make sure that it's aged properly on a routine basis. So, and there's some others, but these are probably the key ones you need to be aware of. And so this kind of limits some of the activities that sometimes go on in the field. And we attend quite a few every year, association meetings or human resource groups in cities where they meet, hotel management groups meet to discuss what's going on. And so there are some things that are pretty clearly you should not be doing. You shouldn't be calling around for information, asking other HR directors at other hotels or general managers for information about what they're paying their employees, because that's clearly an issue. It's a problem. It's already been adjudicated. You can't do that. Exchanging information during meetings is the same issue, where you all come together to have a nice meeting to talk about what's going on in your market area. If you start talking about wage and benefit information at that meeting, that can potentially become a real problem. So you need to be very careful about that. And the other thing that we see a lot of, and we see this not so much from our major competitors like the Mercers of the world and others like that, but we see it at the local level where we have local consultants who will be doing surveys for groups of interested parties in a market area, and they may not be aware of what the guidelines are. And what they'll do is a column-by-column survey where in each column they list all the information by position, by job title, but what they don't do is they don't give you the name of the facility that column represents. But I will tell you that it doesn't take very long in most of these instances for it kind of leaks out. You can kind of figure it out by some of the information that's given by number of rooms and other things. Pretty well start figuring out what each column represents in terms of competitors, and so that becomes a problem. And then of course our surveys, which meet all these guidelines. Here is an illegal column-by-column survey, and the reason I'm putting this out there because this is actually something that we did back in the early 90s before it was clear that you could not do this, and later it became clear with the Utah settlement with the registered nurses that you just couldn't do this type of a report. And so we wish we could do these kinds of reports, but in actuality you can't. So that's unfortunately the short and the long of it, I guess. I think that Bruno is going to talk a little bit about what's going on with the card check situation, which has some implications for ongoing wage issues. Bruno?
Absolutely. For several years now, and a lot of you have probably heard, there was legislation that was called the Employee Free Choice Act. Traditionally, labor organizations, unions, have had difficulty organizing for many, many years. And what they wanted to do with this piece of legislation was go away from the secret ballot election. And the secret ballot election was like any election that we have, that the employees, if they had enough, would have a campaign, both the employer and the union, and then they would go and vote. And it is very arcane. They would basically vote yes for the union or no for the union in a wooden box, and it would then get counted. And it was secret ballot. What had been proposed under the Employee Free Choice Act was that as long as the union presented 50.1% of the employees as having an interest in an election or being unionized, they would get rid of the secret ballot election. In fact, what would happen is it would be presumed that that union organization would be the source, the sole collective bargaining agent, and the employer and would have to enter into collective bargaining negotiations, therefore eliminating the campaign to decide whether to become unionized or not. This saw a lot of traction at the end of the Bush administration, at the beginning of the Obama administration. It never was successfully passed. However, the National Labor Relations Board has systematically tried to make this board, easier for unions to win elections. They have traditionally, it has been viewed that if you have an employer who is dealing with a lot of, you have all the employees vote. And recent case law from the National Labor Relations Board has indicated you can have micro organizations where smaller subsets. And what that means is that a subset as small as potentially, and it was mostly in the healthcare industry, but potentially say just the people that worked in the kitchen, the people that are helping there could be unionized only, or which could only be maybe a small number of people, or only maybe just the housekeepers, the suite attendants, or maybe just the people that worked at the front desk, and that passed legislation to encourage that. They also have put out guidelines to try to shorten the time period where you're allowed to campaign for an election. And they've put in new rules, and those have been challenged in court, and so they are pending, but they are in theory implemented in that the time between intent of an election and the actual election is set down, and the ability to raise issues prior to the election as to representation and how big the subset would be, scrunching the time period smaller and smaller and smaller. And a lot of labor organizations, and the NLRB has allowed this to some extent, have used wage and hour litigation as a means, a leverage point. They will file a wage and hour claim saying that you're not paying your workers overtime, or they're not getting their meal and rest periods, or you're not paying them the right rate of pay. And they will say, we'll drop this wage and hour lawsuit if you enter into a neutrality agreement, which is basically an agreement where the employer says nothing, cannot say anything pro and con, and the union representatives can tell your workers to, in fact, sign up. And if 50.1 sign up, then they become the exclusive bargaining agent. So there are a lot of things going on through the National Labor Relations Board that have been very pro-labor organizations, and they're using wage and hour as a means. Now, there was a recent decision 6 months ago that said that could be deemed during that election period a unlawful benefit and therefore invalidate an election. It was actually a case that I argued and briefed involving a waste management company that was attempting to be unionized, and they had to order a whole new election because they were using the wage and hour litigation for free legal services as a leverage point. So all these DOD guidelines could be used, as well as what's going on in the NLRB, to target hotels. And why are hotels targeted? Because unlike other manufacturing industries, you can't move them overseas. They're viewed as not as savvy as manufacturing to dealing with labor organization tactics, and you're not going to, and so therefore they also view them as having a lot of employees that are similar to janitorial employees, and therefore not as sophisticated. So hotels are a target because a target for labor organizations, and they're especially with these micro units you're probably going to see more and more attempts to organize hotels. I think we should go to the next slide.
Hey, Bruno, what I want to just add into this is just an indication of just where this is all headed, because we work with the American Hotel and Lodging Association in Seattle, because a group by the name of SAGE, a nonprofit that was funded by the SEIU, essentially issued a report saying that hotel workers in the Seattle market were grossly underpaid and at poverty levels, as well as the back-of-the-house employees were paid differently than the front-of-the-house employees, and what they were inferring was there was an issue of color here. And so we worked with the American Hotel and Lodging Association to go in and essentially refute all of their claims with regards to wages and payment, who's paid how much, front of the house, back of the house. And we did that through the data we had collected and refuted their points. But the whole point of this is, just to reemphasize what you said, is hotels are a target. Unions are coming after it. They want more employees unionized, and they're going to use all kinds of pressure tactics, and in this case, essentially, I guess, lies in terms of what they said people were being paid in the Seattle market in order to force unionization. And so they're very aggressive, and you have to be very careful when you're in a situation where their unions are obviously in the forefront pursuing unionization of hotels in a market.
And if I could just add in here, if I could just add in here, Randy, that it's not just Seattle. There are union front group organizations that are being used as community activist organizations. In the Bay Area, there's a group called the East Bay Alliance for Sustainable Economy, or eBase. We're seeing ROC, which started in New York and is now is trying to get more of a foothold in Los Angeles. Acorn was one group that was done nationally. So there are a lot of organizations that are out there that are supposedly community activists, but really they're being funded and being supported by SEIU, by Unite, by HERE, by the AFL-CIO, and their goal is to organize certain businesses that can't leave the area because their service industry businesses and hotels and restaurants are number one and number two there. Let's talk about the current price-fixing cases that were just filed this month in California, the Greenberg versus Expedia case and the Romanelli versus Expedia case. Both of them were filed. One was filed on September 18th, that's the Romanelli case, and the other one was filed on September 24th of this year. They're both pending in the United States District Court for the Northern District of California. And it's interesting to note because they're talking about a nationwide scheme. And the choice of forum of the Northern District of California is very interesting because the reason I suspect they chose the Northern District of California as opposed to the Southern District of California, which is San Diego, or even the Central District of California, is traditionally Northern California has been much more labor friendly. And in fact, statistically speaking, there is more based on registration of cities and communities in California. Nowhere else in the country or in California are the registration 90% or more pro-union and single digits anti-labor organizations. And that's what you're talking about in Northern California. And while this is federal court, the Northern District has been seen, because of the juries they have there and because of the area, as much more friendly to labor organizations than other district courts, say even the district courts in New York State, which is a very union-heavy state, or Pennsylvania, and obviously the more southern states are less receptive to labor organizations, and Illinois is less receptive, even though Chicago is a major labor organization place. So it was systematically done, we suspect, to bring it to California, which is much more friendly. And let's talk about what these price-fixing cases in fact are. Most of you probably heard of it. As hotel operators, more and more bookings are done through online services such as Expedia, Hotels.com, Travelocity, Priceline, Booking.com, Orbitz. And what they're alleging in both these cases, and they're similar, using the Sherman Antitrust Litigation Act as the foundation, is that they're unfairly restraining trade. In fact, they're claiming that all the defendants, and a lot of them are all those online services, as well as major hotel companies such as Hilton, Starwood, Kimpton, Intercontinental, Wyndham, Travelodge, as well as other, including the Trump International hotels. Those are the named defendants, but they even name, keep it open to name other defendants. And what they're basically saying is that there is a price-fixing scheme that was done so that all the online retailers are all going to give you the exact same price. You know, the best guarantee, the discount, that no matter where you go, it's going to be the same price. And that there was a that they basically imposed a minimum resale price maintenance agreement on all the retailers, and they refused. The supply was basically cut off, and that they basically reached an agreement that reservations would not be sold, would be sold to everyone for no less than a particular rack rate. So that all the hotels, they agreed that it's going to be the same rate no matter where you go. And the allegation is that they violated the Sherman Antitrust Act, the California False Advertising Act, the California Unfair Competition Law, as well as the California Consumer Legal Remedies Act, that they basically, by setting a rack rate price no matter what it is, and that it was already agreed to, that they could have gotten these rooms for actually less if they had open competition. But that they basically have stifled the competition, and that the amount you're going to pay, no matter what website you go to, is going to be the same. And they talk about 3 different models to accomplish this. And just so you know what's being alleged, the 3 models are the agency model, in that the online retailers, the Orbitses and the Pricelines, charged a service fee to all the hotel operators on a transaction basis for booking customers into rooms at a given hotel, and the consumer pays the hotel directly. And under this model, the hotels should be setting and requiring a competitive price for room reservations to increase business and compete against other online retailers offering the same service. The other model they're alleging is the merchant model, in that the online retailers do not function merely as the service providers collecting a fixed fee from the hotels, but rather they consist of 2 independent but related transactions, whereby an internet travel company first purchases or takes title to the inventories in hotels' rooms as a negotiated rate with the hotel companies, and then they resell the rooms at a higher retail rate, keeping the difference in the profit. And the online retailers should be competing with one another by increasing or decreasing the margin added on the retail prices to set the retail rate. And the third model is the wholesale model, whereby smaller price-cutting online retailers obtain access to rooms through wholesalers, and the wholesalers are intermediaries between the online retailers and the hotels, work directly with the hotels to obtain last-minute blocks of rooms. What they're basically saying is that these 3 models are jury-rigged, and that it's going to be the same price no matter which way you do it, and they cite a bunch of examples. And the interesting thing is, when they look at the examples, is very few of them, quite a few of them are from San Diego. Some of them are from Illinois. Some of them are from New York. Only a couple are from, I don't think they really allege any from the Bay Area, but all of this is alleged. Well, what does this all mean, that this price fixing under the Sherman Antitrust Act? What they're asking is for class action status, and they're basically claiming under both these cases that the class is numerous. It's a nationwide class, and that the common questions of law predominate. It's too large to manage as separate things, that the claims are same, they're typical, and the common questions predominate. And those are the 4 criteria that you need to have a class. And they're basically saying that these people are representatives. One is alleged to be a San Diego person, the other one a New York State person, and that they're basically, the conduct is all the same, and that they even cite some examples where there was communications between some online servers as well as hotel companies, and that it's superior to do this. If they do, and they want to certify a class, and why class action is so dangerous for anybody is that once you have a class, then it basically becomes less about what reality are and more about extrapolating the number. For example, if one person was undercut, $50, then they say that everybody was undercut $50, and you have 1,000 people, then you add that up, and that's $5,000 or $50,000, and they make it a math contest as opposed, they just want to use models as opposed to looking at reality. And what they're asking for here is not just, they're asking for money damages to reimburse the plaintiffs for how much they could have gotten less, but what they're really looking for is the attorney's fees and the costs, because this is a attorney-driven lawsuit. Of course, they're asking for injunctive relief that this practice stop. And they're also asking for treble damages under the Sherman Antitrust Act. And so defending these cases is a very expensive proposition, and the plaintiffs want, millions upon millions, and my guess is that their claims are hundreds of millions of dollars that they want to collect from all the named defendants. And they want all their attorney's fees, which will get well up into the millions themselves if they go forward. So it is a lawsuits that were recently filed. They're being consolidated. In fact, an order just came out on September 28th, not consolidating the Greenberg and Romanelli case, but consolidating other cases that were previously filed. And right now it looks like they're going to be in front of District Judge Jeffrey S. White, but that could change. So we're in the Northern California District. You're saying there's price conspiracy, that in fact there can't be a free market, and that in fact the hotels and the online retailers are designating the rack rate. It's always going to be the same rate no matter what, and they're going to charge higher rates than what if a free market could charge. And that's what's going on here in California in a nationwide class action suit, and it's less than a month old. Randy?
And the point of all this is this is kind of like a roadmap for what could happen with wages as well, and that's why we try to avoid the situation where they can claim that there's collusion going on between individual hotels in terms of the wages they're paying, but you can see where it would all head if it starts to, if the unions begin to move it in that direction. So that's why the major hotel companies across the country, they try to limit the amount of information that's being exchanged between hotels, especially when it comes to wages. They don't want anything being given between properties. So, and then kind of for those who haven't seen our survey, this is a report from our survey. What this report doesn't show is above it, we list all the properties that provided data for this report. And you can see, if you look at the column called reporting, you can see there's just at least 5, and you can see the 25th percentile, the median, the 75th percentile, the average, as well as if you put data in, your data would show here, and the variance you have. You can see where we have less than 5 properties, only 4, no data is provided for those lines. So that's how we implement the DOJ rules to make sure that that this doesn't become a Sherman antitrust problem for the hotel industry. Just to give you a quick idea of some of the, and this is just a partial list of the management companies we work with. The ones that are in asterisks in red, they actually provide us the data for their properties across the country in a payroll data upload that we get from them, which we put right into our system directly, so that the individual properties do not have to put in the data, which saves a lot of time for the HR directors who have a lot of important things to do on a day-to-day basis. So kind of brings us to the bottom line is why hotel gaming companies use WageWatch. Because our data is accurate, and the data has been tested many times by hotel companies and other groups, even other consulting groups, who have found the data to be very accurate. And again, because we comply with the guidelines, so therefore it's a safe harbor for the users of our survey. They know that they can always point to this where they get their wage information, and it complies with DOJ guidelines. Therefore, there is no violation of the Sherman Antitrust Act at this point. So that's pretty much the presentation. I think we're pretty much on time here, Janae.
Yeah, perfect actually. Let's see. We were actually scheduled, I think, to end at 10:45, but we didn't lose anybody, so apparently like, we're still very much into the your presentation. Well, I'd just like to thank everybody for attending. And just a quick reminder, October 15th is the deadline to get your Stars of the Industry nominations in. And then also our next webinar coming up on November 9th, which is a Friday, and that's the post-election legislative update, going to be presented by public policy advocates. So again, thank you so much, everyone, for attending. You have everyone's emails if you have any questions or would like to request copies of either of these presentations. And I hope everyone has a wonderful day. Thank you again.
Today, what I might add is Randy,
Yes.
WageWatch. If they go out to our website, WageWatch.com, there's a tab at the top called Blog, and we actually posted like a two blog session white paper on how to comply with the guidelines. So if anyone's interested, they can get more information there.
Awesome. Okay, and your website is listed there.